Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living in Utah. Today we're continuing our series about common estate planning fails. These are things that people do, whether with or without the help of a professional, that can really throw a wrench into the estate plan, and which is why it's important to go to someone who specializes in estate planning. The one today is going to be about who is a child of yours or a grandchild. What is a child under Utah law? A lot of people assume that anyone that they would consider a child of theirs, of course, is going to be considered a child by law, and that's not necessarily always the case. If you have a child biologically, you're on the birth certificate, and your rights were not signed away or otherwise terminated, then that is a child of yours according to Utah law. However, adopted children also fit that definition. So if you have adopted children and they are considered your children for adoption purposes, they are also considered your children for estate planning purposes. So keep that in mind. Oftentimes I'll see families who have adopted a child, but sometimes do not want to consider that child a child of theirs for estate planning purposes, and then sometimes they do. It really just depends on the family, but just be aware, in Utah, an adopted child is a child for estate planning purposes. Another one is foster children. A lot of people who foster would not consider their foster children their children, but some do. And it's important to keep in mind that foster children are not considered children of yours for estate planning purposes. So if you have, whether in a will or without a will, and the statute would leave everything to your children, foster children are not included there. Then finally, stepchildren. Stepchildren are not considered children of yours for estate planning purposes, and so you need to plan accordingly. What I usually see with families is they'll want to leave everything to their children or their grandchildren, but they don't realize who is really considered a child or a grandchild of theirs. A lot of times, if in the grandparents' case, they'll have a child who has married somebody who already had children, and those children become their grandchildren, essentially. They treat them as grandchildren, they love them as grandchildren, and sometimes they want to treat them as grandchildren for estate planning purposes and make sure they receive something in their inheritance. It's important to remember that those need to be affirmatively included, like one who would be adopted would be affirmatively excluded if you wanted to exclude them. So keep that in mind. Adopted and biological are considered children for estate planning purposes, however, step and foster are not. Thanks for watching. If you have any other estate planning questions for us, please feel free to reach out at any time.